Okay. I'm going to ask Mac Jackson, before you start, got something else I want to say. I'm going to ask him to pray for us today, tomorrow, and Monday. Well, he can pray for us at home Saturday and Sunday, but I'm going to ask him today, tomorrow, and Monday morning to pray for us. Mr. Jackson.
Thank you, Mr. Chairman. Let's bow our heads. Heavenly Father, as we come before you, we thank you first of all for this day. For Father, this is the day that you have made. We thank you for it in the name of Jesus, Lord. And now we ask for your leading, your guidance, and your wisdom as we continue to do the business for the state of Georgia. Bless us, Lord, in a special way so that the people of Georgia may know that we're all for their good. In Jesus' name, amen.
Thank you, sir. All right. Before we have our illustrious chairman over there present the budget, I'd like to make a couple of comments as to the next 3 days. I want to apologize up front if I say something to hurt your feelings. It's nothing personal. I'm tired. I'm being stretched from both ends, which is okay. But it's nothing personal, and I want to apologize up front so that you know I'm sorry. So I'm going to turn it over to Chairman England. So he's got that little thing, House Bill 81, I think.
Good morning, Mr. Chairman. Thank you.
You know what he had the nerve to say yesterday? Sitting down in the chair, and he said, you know, I think you need to have breakfast before you have rules because you're mean in rules.
And I forgot to bring it, didn't I?
You forgot to bring it. Go ahead, sir.
Good morning, everybody. In front of you should have a copy now of the committee sub for House Bill 81, which is the FY22 state budget. Refer to it as a simple little housekeeping bill. It does fund our operations from July 1 of this year until June 30th of next year. We came out of subcommittees into full committee this morning and had full committee, and it passed in full committee, and I think we're ready to be on the floor tomorrow, Mr. Chairman.
That's what I understand. I think everybody in here is on at least one subcommittee, and you had the opportunity to watch it, the whole presentation this morning. Does anyone have a question for the chairman? Seeing none, thank you, sir.
Yes, sir. Thank you. We'll see y'all tomorrow.
And I appreciate you allowing me to use your room.
Yes, sir. Absolutely. Glad to. I appreciate it. Clean it up a little bit better, though, when you get done each day. Been having to come back up here before I leave at night, take out trash and such.
Yeah, that's right. I was just reminded that the chairman was not on the blue sheet, but I think he does take priority over the color of the paper we got up here. Do you have a question for the chairman?
Okay, I guess it's a difference.
Use your microphone.
No, I'm sorry. It added up differently, but it's in the.
Okay.
That was all. Sorry, sir.
That's all right.
Good catch. The reason that number is different, the first number you see on the governor's revenue estimate was his original. We received a letter raising the revenue estimate by 7.6 and change about 2 weeks ago to recognize the dollars from the rideshare fees that go to transit. So that's the reason for the difference. Good catch, though. Thank you.
Thank you. Sorry.
Good catch. All right, seeing no more questions. Okay. All right, let's see. We've got several people who have bills that they want to present. Ms. Lewis, is Representative Gamble here? He has House Bill 92.
Good afternoon, Mr. Chairman, members of the committee. I'm here to request House Bill 92, which will change the dates for the eligibility for vital records, particularly as it relates to birth certificates and death certificates, back to the previous specification, which was 100 years for the birth certificates and 75 years for the death certificates to the state archives.
See no questions. Thank you, sir.
Thank you.
All right, Representative LaRicchia. Okay, House Bill 346.
Yes, sir, Mr. Chairman, members of the committee. I present House Bill 346. It's third from the bottom on page 1. And this is for individuals that suffer from a rare disease, congenital adrenal hyperplasia. They have to carry a medication with them 24 hours a day, 7 days a week. They have a bracelet that's a medical alert bracelet. What this bill simply does is allow paramedics on EMS services to be able to administer that shot for them. And that's what the bill does.
Okay, got one question, Chairman Hawkins.
Without this drug, these young children and infants, would they die if they did not get this drug within a timely
It does,
amount?
and the bill clarifies that they have to be in crisis.
Right.
And if they're in crisis, the shock of that could kill them before the accident would that they were in.
Right.
Where the EMS had to respond.
Right, great. Good bill.
Thanks, sir. See no more questions.
Thank you, Mr. Chairman.
Well, hold on, one more. Okay, number.
Thank you, Mr. Chairman. This is a kind of a joint question me and the leader came to. Is this something that they typically carry on the ambulances?
It is not. Some states have passed requirements for them to carry it, but we really didn't want to go that route with a mandate to make every ambulance carry it. Those individuals that suffer with CAH have to carry, they call it a care bag.
Okay.
24 hours a day. It's in their schoolrooms. It's with their baseball coaches. If they spend the night with grandma, that bag has to be with them 24 hours a day. If an EMS paramedic comes up, it has instructions on how to administer it with intramuscular shot and the expiration date, and the seal can't be broken on it. The expiration date has to be good, that kind of thing.
And so they'll have it, the EMT will just administer it.
That's right.
Got it. Thank you. Good deal.
Thank you.
Okay. No more questions. Thank you,
Thank you,
sir.
Mr. Chairman.
All right, Representative Collins, House Bill 364. Floor is yours.
Thank you, Mr. Chairman, members of the committee. I bring to you House Bill 364. It's on the bottom of your blue sheet. It's a very simple bill. If you will think about security guards. Right now in the state of Georgia, if you want to be a security guard and licensed under the Secretary of State's office, you have to submit for a background check, fingerprints, and they take the time to award those licenses. What this bill is doing is allowing peace officers, those post-certified officers, to go to work in a security guard role for a security company and have up to 60 days to get their license by the Secretary of State's office. These post-certified officers, are educated. They're certified by the post-certification. This also keeps them from having to send in the 2 fingerprints. Currently, if you're post-certified, you've already been vetted by that organization. So this just streamlines that process and allows those post officers to work in the role as a private security guard for a company.
Okay. Any questions from anyone? All right, seeing none. Thank you, sir.
Thank you very much.
All right, Representative Werkheiser's next. House Bill 532. Werkheiser's not here. Okay. Okay. What's your number, Chairman Benton? Okay. I turned them all on, so.
Thank you, Mr. Chair. Chairman Werkheiser just asked me to mention this to the committee, that 532 is annual agency bill from the Department of Labor. Would appreciate the committee's positive consideration.
Okay. Any questions from anyone? Seeing none. Thank you, sir. All right, Representative Oliver, is she here? House Bill 579.
Thank you, Mr. Chairman. House Bill 579 is on page 2, a little bit more than halfway down. The creation of an opportunity for 159 counties to create a Public Safety and Judicial Facilities Act authority was created in 2003. The only county that's used this small opportunity to fund jails and fund courthouse is DeKalb County. And based on some internal issues of DeKalb in 2007, the General Assembly imposed a referendum on this authority. It's the request of DeKalb County and Michael Thurman that the referendum be removed from the act. It's totally an anomaly, not used for water authorities or hospital authorities. So I ask for to be placed on the calendar for 579.
Okay. 5-7. Any questions for the lady? Seeing none, thank you.
Thank you, Mr. Chair.
Okay. Representative Hogan. He has House Bill 591.
Thank you, Mr. Chairman and members of the committee. I bring before you today House Bill 591, LC 338644. On your blue sheet, it's second page, it's about halfway down. This bill came out of the Georgia Behavioral Health Reform and Innovation Commission that was met all last year. And basically what the bill does is allow licensed marriage and family therapists to do 1013s and 2013s. And licensed marriage and family therapists are professional mental health providers trained in psychotherapy, systemic treatment models, and licensed in Georgia to diagnose and treat mental and emotional disorders. And basically that's the bill.
Okay. All right, Chairman Jaspers.
Thank you, Mr. Chairman. I have just a question, specifically from my sheriff. Could the family and licensed or managed counselor, could they create a 1013 without speaking to the person involved?
Yes.
And that means included from an unhappy spouse, interested a difficult family member. They could do that without meeting with them.
As other licensed professional people are able to do that also.
Okay. Thank you, Mr. Chairman.
One of the, got a question? Go ahead.
Chairman Hogan, what other professions can issue 1013s? I know it's not in the bill, but
The licensed counselors in alcohol and drug, mental health professionals who are also licensed are able to do that.
Okay, thank you, sir. Chairman Powell.
Thank you, Mr. Chairman. I'm vaguely familiar with the 1013. What's a 2013?
2013 is for alcohol and drug.
Okay, 27.
Thank you,
Chairman Ballinger.
Thank you, Mr. Chairman. What are some of the fallouts? What happens whenever somebody gets 1013 or 2013?
They go to a mental health center for evaluation up to 72 hours.
So they have to be basically incarcerated. Is it a secure facility?
Yes, it is.
So they're incarcerated for 72 hours from somebody
Not necessarily for 72 hours. They can be there for 72 hours, but that's for the professional of the mental health center to make that determination.
Okay. So on the basis, the mental health, the family mental health people, that they can, on their signature without even seeing somebody, they could have somebody get locked up for 72 hours?
Up to 72 hours, and their life must be in danger or endangers the life of someone else.
Okay, thank you.
All right, I don't see any more questions. Thank you, sir.
Thank you.
Okay, Representative Nix, House Bill 606. Floor is yours, sir.
Thank you, Mr. Chairman. I'd like to ask for House Bill 606. It's on page 2, 5 from the bottom. This is that elusive, simple little bill. All this does is add the Georgia Independent School Association to the list of officially recognized accrediting agencies for our schools in Georgia.
Well, I don't see any questions. Thank you, sir.
Thank you.
Okay, is Chairman Chokus outside? There he is. House Bill 611.
Thank you, Mr. Chairman. Members of the committee, I bring before you House Bill 611 LC 500185. This simply takes the definition of small business under Title 50 and puts 3 subdivisions underneath it. Tier 1 is 10 employees or fewer and $1 million in sales or less in annual sales. Tier 2 is 100 and fewer employees with $10 million in annual sales. Tier 3 is currently the definition 300 or fewer employees and $30 million in annual sales. And the reason for this bill is to enable the state of Georgia to focus more precisely state procurement dollars on small business and also in the future offer incentives to enhance job creation. And I'll be happy to take any questions.
Okay, Whip Kelly.
Thank you, Mr. Chairman, and I think the gentleman's answered largely what my question is. Today, practically, we're just putting in the tiers so that we can then evaluate potential opportunities to help the different tiers at different levels. Is that correct?
That is absolutely correct.
All right, thank you.
Okay. That's all the questions I see. Thank you, sir.
Thank you, Mr. Chairman, members of the committee.
All right. Chairman Houston. And 619.
Thank you, Mr. Chairman. I bring you 619 on behalf of Department of Natural Resources, and because it's in my district of Berrien County, Patrick Fish in Paradise has approximately 900 acres in a heritage trust, but there are 8 acres on the other side of an abandoned railroad bed that they would have no use for because Patrick Fishing Dice is a fishing operation, not a wildlife management, and they would like to either lease it or sell it and just not keep it up. And I have a map, and I don't think y'all can see it, but I think we had one in on our roads thing. It's 8 acres. And the reason we have the description of the property in this bill is because we do not want to disturb the Heritage Trust, and we don't want any other people to think that they could take things out of the Heritage Trust without going through this process. And the land will not be sold or leased. First of all, it'd have to go through the DNR board to recommend it, and then it would have to go through our committee again if they sold the 8 acres.
Okay. You have a question, Whip Kelly?
Thank you, Mr. Chairman. Just to clarify, so we're keeping the majority of the Patrick's Fishing Preserve active, and we're just conveying an 8-acre portion that's on the other side of the road.
In the bill, there's a legal description of the 8 acres that they would either like to sell or lease.
Got it. Okay.
And it's on the other side. I don't know if you know what abandoned railroad bed is, but it's on the other side of that.
Yes, ma'am. Thank you.
Thank you.
I was just looking out for Patrick, wanted to make sure we weren't getting rid of his fishing preserve all in totality.
It's approximately 900 acres in the fishing paradise. And come on down and fish. We'd love for you to.
I'm waiting on the invite, Madam Chair.
All right. No more questions. Thank you, ma'am. Representative Leverett. Are you going after the record?
I think Stan Gunner's already bested me, Mr. Chairman.
I think he has too. But you're running a close second.
Well,
Go ahead.
Thank you, Mr. Chairman. That's my usual place in life. Mr. Chairman, I appreciate you and the members of the committee considering House Bill 620. It's a bill that increases from $15,000 to $25,000 the cutoff at which a settlement of a child's claim must be submitted for some kind of court approval or a conservator must be appointed. The reason for upping that amount is that the $15,000 was set many years ago, and of course with inflation, it's basically adjusting that number, and the purpose is to keep more of that settlement in the hands of the child or the child's parents rather than have it consumed through legal proceedings and court costs. The bill so changes that amount, and it also tries to clarify as the amount of the settlement gets higher, a higher level of scrutiny, which would require approval of the court in which the claim is pending, or appointment of a conservator, or appointment of, or approval by a probate court. And the bill is clear that a conservator has to be appointed to receive the money, and they have to apply and post a bond once the amount of the settlement is determined.
Okay. Representative Williamson.
Thank you to the author of the bill. Thank you for bringing this measure, but isn't it true that this is probably a result of when this $15,000 limit was set? That was when the minimum limits of liability in Georgia for automobile insurance policies was $15,000 per person, $30,000 per accident, and now that minimum is $25,000 per person and $50,000 per accident. So isn't it true that oftentimes people are due, they get paid in full, the bodily injury limit on a not at fault, when they're not at fault, and sometimes the beneficiary of that settlement's a child that their parents can't afford to take the necessary legal steps, and this would solve that problem. Is
Yes,
that not
yes,
true?
sir, and thank you for raising that point. I appreciate that question. That's absolutely right.
Chairman Hawkins.
I'm seeing your name on these blue sheets so often. I'm starting to wonder if your first name's Judy, or maybe you're married to Judge Judy.
I can affirm that neither of those are true, Mr. Chairman, but I appreciate the compliment.
Okay. See no more questions? Okay. You're on now.
Yes, sir. If I understood the gentleman said you're going to from 15 to 20, correct?
25.
25, okay. I don't have a desk right here, so I didn't have it open. I was going to question. I thought I heard 20, and I was wondering why not 25. Thank you.
Thank you, sir.
Okay. Now I see no more questions, I don't guess. Okay. Thank y'all. Thank you, sir.
Thank you, Mr. Chairman. Thank you, members of the committee.
Representative Gravely, House Bill 645.
Good morning, Mr. Chairman.
Good morning.
Let's have a simple marijuana bill. That's all it is, Mr. Chairman. No, it's a cleanup bill. After the 2 years ago, this body passed House Bill 324, which provided for cultivation in our state, formed a commission. That commission has been approved. They have been working for.
Sorry about that.
It's okay.
Go ahead.
They have been working over the last 2 years to try and work through their way legally in getting applications ready. The applications have been released. They have been returned. 70 applicants submitted applications to be cultivators here in this state. So it should be by the end of April. The Department of Law over at the Attorney General's office simply worked with them, asking for some clarifications. I wanted a clarification on products, which was defined in House Bill 324. We're not adding anything, we're simply clarifying what we did in 324. So the only use of this particular product could be used through a tincture, a transdermal patch, a topical oil, or a gelatin capsule. That's it. We're not adding smoking of any kind. We're also adding credit unions. They came to us and wanted to be a part of this, to be able to participate in the financial aspect of being able to bank the proceeds. We're also adding the capability for our research and development universities and colleges to provide data for those companies that have received a license. And I want to be clear on this. The only 2 schools in the state of Georgia were allowed the opportunity to grow, and that was our 2 land-grant universities, University of Georgia and Fort Valley State University. They have yet to do that, so we're not going to force them. We're not going to mandate that they do. If ever they want to, they can come forward. But other schools around the state, like Georgia Southern, Payne College, Clark Atlanta University, Spelman, have expressed an interest in partnering with one of the 6 licensees just to provide research and development. They will not be growing on their campuses. Number 4, we added the medical composite board to assist with the GBI to ensure the compliance in investigating any bad actors. So, Mr. Chairman, that's it. It's truly a cleanup bill. We're not adding diagnoses in this bill. We're not extending anything. We're just cleaning it up after the direction of the Attorney General's office.
Okay, Chairman Cooper.
Representative, at one point, it was my understanding that you were contemplating putting in where we could have, rather than the 6 people that can grow this stuff now, that you were expanding that to other people. Does this bill have any expansion in the number of
Licenses.
growers?
No, ma'am. All it does is if it only 6. We're not expanding that to 10, to 14, nothing like that.
Okay.
There is a provision that the commission, if one of the growers goes bankrupt, proves to be a bad actor, that the commission can then replace the license there.
Okay, but no expansion whatsoever?
No expansion. We're not adding licenses or saying that there'll be more than the 6 that have yet to be appointed.
Thank you.
Yes, ma'am.
Anyone else have a question that I haven't seen? All right, no more questions. Thank you, sir.
Thank you, sir.
Representative Vance Smith, House Bill 647.
Thank you, Mr. Chairman, members of the committee. I bring to you 647. It's at the top of the 3rd page. This bill is pretty much identical to a bill we passed out of the House last year that was House Bill 929. This is an impoundment of coal ash that's generated by electric companies, and it has a yearly inspection, but the big item is they inspect it and monitor out 30 years, and I increase that to 50 years. And it also has a reporting mechanism, and in that reporting mechanism, with all the data, it has to be in layman's terms, since most of us are not experts in environmental issues and technical issues, so it has to be in layman's terms. There's an inspection while they close it annually, at least annually, and then every 5 years after, at least every 5. So EPD does a great job of that monitoring, and I sure would appreciate your consideration in this matter.
Chairman Smith.
Thank you to the bill's presenter. I'm over here toward, all right. Thank you very much for bringing this legislation. It addresses many concerns that people have living near and around these compounds where landfills where their coal is kept there. It has the full support of both subcommittee and committee. Thank you.
Thank you, Madam Chairman.
See no more questions. Thank you, sir.
Thank you, Mr. Chairman.
Representative Cantrell, House Bill 675. Okay. All right, is Representative Rhodes here? Okay, is Chairman Knight, you want to comment on Representative Rhodes' is House Bill 343? I think you have a substitute.
Thank you, Mr. Chairman. There were some issues regarding 343. This dealt with hunting without permission on land. There were some concerns we heard from the members, and what we've done is we've taken some of the concerning language out. We left the original bill, which was just simply upping the fine for the second and third time that someone's caught hunting without permission on somebody else's land. There's two issues here. We want to respect private property rights, and so it's wrong for people to go and do that. Second of all, we don't want people hunting on other people's land. There could be accidents, and there's a safety issue to it. So we think this is the proper tempered measure at this point. It's just to look at the fines, and we'll see if this helps.
Okay, the substitute is LC 441699S, and that was a version that Chairman Knight just explained. Do I hear a motion? Move and a second. All in favor say aye. All opposed, like sign. House LC 441699S passed. Okay. Let's see. Chairman Stevens. You probably need to go to the microphone too. He's got 4. And first one we'll do is substitute for House Bill 86.
Thank you, Mr. Chairman. This is the sports betting bill. As explained earlier, this is an issue that we have, that 2.3 million folks are doing now in Georgia, your neighbors, at $4.8 billion. The substitute here adds some language for the lottery reserve. Currently, the law says that you have to keep 50% of the previous year's revenue in there. This continues that, but it also provides a ceiling at 60%. We're about to add $100 million if this passes to the lottery. This makes sure that that does not go into an over subsidized reserve, so that money goes to the folks that deserves it. That's what it does, Mr. Chairman.
Okay, so there's nothing in here about horse racing or casinos, right?
No, sir.
Okay. Okay. That's probably going to end up in a structured area. Okay, House Bill 86 substitute. The substitute number is LC 364744S. 364744S. Do we have a motion? Got a move and a second. All in favor say aye. Aye. All opposed, like sign. All right, it passed. LC 364744S. Thank you. All right, now you have 316.
Thank you, Mr. Chairman. That bill passed out of committee. It moves the pharmacy technician ratio from 3 to 1, one of those being a certified, to 4 to 1, 2 of those being certified. That's all it does.
Okay. I see no questions. Thank you, sir. House Bill 469.
469 is, this one only extends the sunset 1 year on the current historic rehab project.
Okay. See no questions. Thank you, sir. Okay, House Bill 601.
On the heels of Representative Gravely, House Bill 601 regarding medical marijuana, low THC, clarifies and makes sure that nobody classifies this as a Class 1 narcotic. This is a medical marijuana product. Epidiolex is the first one that's out. And this makes sure that we, through our drug updates, don't reclassify this as a Class 1 narcotic, that it is used for 5 medical conditions, and that it won't be reclassified wrongly, if you will.
Okay. Anybody got a question for the chairman? Seeing none. Thank you, sir.
Yes, sir.
Okay. Representative Powell, House Bill 369.
Thank you, Mr. Chairman. House Bill 369 would authorize physician's assistants and advanced practical nurses working under the protocol of a physician to do 2 things. One would allow them to issue Schedule II drugs for up to 5 days, and for them to issue the handicap placards. In regards to the Schedule II drugs, the doctor's protocol would have to be posted with a composite board, and they have 10 days to respond. If these physician's assistants or APRNs are dispensing these Schedule II drugs, then they've got 5 days max supply that they can do it, and they have to report within 72 hours back to that physician of what they're doing. So it's all pretty well strictly monitored. This is a practice that's accepted amongst surrounding states and most around the country for the benefit of the patients.
Okay. See no questions. Thank you, sir.
Thank you.
All right. Chairman Cooper, House Bill 377.
This is the bill that would allow judges across our state to, I can't think of the word, to postpone a pregnant woman's admission to our penal system until 6 weeks after they have delivered. We have one prison here not too far from the Capitol, but to say that the kind of care that a pregnant woman would get while in our penal system is to talk about a substandard situation despite efforts to do differently. And the judge has the discretion that if he thinks the person is safe and not going to be a harm to others or to themselves, they have the right to postpone their time to when they enter the prison system and start their the clock on their prison thing. The woman can also ask to go. And that would be like if perhaps some woman had been trafficked and had come up pregnant and was afraid that they would need to stay away from the person that was trafficking them, or some situation like that, or they have no place to go.
Okay. All right. Any questions? Okay. Chairman Cooper, House Bill 605.
605, I wish I had named this the Sunshine Nursing Home Bill. This puts parameters in on the use of cameras and brings them out into the daylight, hopefully, so families that have been so worried during this pandemic about what's going on and what's happening to their loved ones can opt to put a camera in the room and watch their families if they want to, 24 hours a day, just like I could watch my corgi when it went to doggy daycare. It does put parameters, like it makes sure that they are responsible for the installation and any cost that's associated with it, and the cost of running it except electricity. And it also protects the right of roommates. Most of the time in our nursing homes, there are 2 people in a room, and the roommate does have certain rights. And so the bill spells out what those are, while still making sure if there are egregious cases that they can go and be, they can go to court and fight it out and be taken care of that way.
Okay, you got a couple of questions. Representative Williamson.
Thank you, Mr. Chairman. To Chair Cooper, is it not true that y'all work very hard on this? And I'm just an interested observer, didn't serve on the committee, but I got just fantastic. Is it not true? I got fantastic reports about how hard everybody worked on this measure to make sure that privacy rights were protected, and yet it has the intended effect of giving families the opportunity to make sure that their loved ones are getting the care and attention that they're frankly paying for.
Thank you. It has been carefully worked out. I beat up pretty hard on nursing homes, as their attorney said, because I'm a patient advocate and I want the patient's rights first. But they have worked together. The trial lawyers have been on it also. So we've worked very diligently on this bill.
Okay. You've got one more question. Who's 79 back there? Representative Hughley.
Thank you, Mr. Chairman. I think my concern has been answered. My concern was about the privacy of the roommates, and I think she's already addressed that.
Okay, thank you, sir. Ma'am. Okay, no more questions? All right, Representative Newton, or Chairman Newton, House Bill 450.
Thank you, Mr. Chairman. House Bill 450 matches the approved research release language for de-identified data in the medical cannabis registry. It'll make it match the same language that's currently in the PDMP, which is opioids and other controlled medicines. Both definitions are held in DPH and would allow appropriate confidential research to be done.
Okay. Any questions? Seeing none, okay. House Bill 697.
Thanks, sir. House Bill 697 would add language to the already existing annual hospital questionnaire. It would include an information from their hospital's electronic health record vendor that would tell whether or not that vendor's system allows needed access by other hospitals or specialists when they're caring for a patient. And then the second question it would be is, if not, what are the barriers, and is there a timeline, is the third question. It would just add those to the annual hospital questionnaire.
Okay. See no questions. Thank you, sir.
Thank you.
All right. Chairman Lumsden, House Bill 451.
Mr. Chairman, members of the committee, I bring to you House Bill 451, page 3, under Structured Rule, third down. This bill comes as a request from the Georgia Association of Manufacturers. It provides an optional way to determine the applicable fair market value on inventory for which a level 1 Freeport exemption is sought. Little way, by way of explanation, the situation where an order was placed pre-COVID, the manufacturer filled the order, and the order was canceled due to COVID. As a result, the manufacturer is sitting on inventory which he would not otherwise have were it not for the fact that those orders were canceled. This is a one-time fix to deal with the Freeport or the inventory for which a level 1 Freeport exemption is sought. This only applies to eligible finished goods inventory for the year 2021, and it bases the valuation on the fair market value of applicable inventory as of January the 1st, 2020, or the fair market value for the applicable inventory as of January the 1st, 2021, whichever is lesser. Just provides for a one-time relief for an applicable fair market value.
I see no questions. Thank you, sir. All right, Representative Carson, let's do your rule substitute for 517 first, and that's LC 490502S.
Thank you, Mr. Chairman. This is a proposed rule substitute, LC 490502S. Thank you for that. This incorporates the finding. This is in regard to the Qualified Education Expense Program that we have, Mr. Chairman. This incorporates the findings of a recent audit released in January on the QE program and includes some disclosures such as making it very clear to the Department of Revenue to post the audit results and in a timely fashion from the audits of these SSOs. It makes this program look and feel a little bit more like the Rural Hospital Credit Program. There are no increases in this cap. The cap is $100 million, as you remember, all the way through 2028, and it goes down to $58 million after that. There are no increases in the cap. There are increases similar to the rural hospital program. There are increases in the individual caps. So how much an individual can do, how much a married filing joint, but no increase in the program whatsoever. Other than those increases, this is about disclosure and transparency as per the Department of Audit's recommendation, sir.
Okay, so that's LC 490502S, a rule substitute. Do I hear a motion? Got a move and a second. All in favor say aye. All opposed, like sign. Okay, this is a version of the bill on the House floor at some point, 490502S. All right, you still have one more, House Bill 545?
Yes, sir. LC 49047S, House Bill 545. This is an issue we've been talking about for a number of years in this Capitol. This allows homeschool students, homeschool study students to participate in public school sports within certain parameters. They must attend one course in their resident school, the school that they would be going to. This only affects middle and high school. The child must take at least one course, either face-to-face instruction or virtual, or a dual enrollment course may qualify. I just want to thank Chairman Rick Jaspers and all his work the past couple of years on this and handing this to me to carry. We've done this with collaboration, not conflict, but really with collaboration between our friends at Georgia High School Sports, GHSA, the homeschooling community, Department of Education feedback, and so forth. And I've just got a number of guidelines and guardrails in the program to prevent abuse. I'm sorry. And I just appreciate the committee's favorable consideration.
Okay. Any questions? All right, seeing none. Thank you, sir. Okay, Representative Ballinger, House Bill 582.
Thank you, Mr. Chairman. House Bill 582 makes our probate court judge. Right now, our probate court judge in Cherokee County is a partisan election, and this would just move it to a nonpartisan election judicial best practices always dictate that our judges be fair and impartial, and part of that is being nonpartisan. So I'd be happy to answer any questions.
Okay, I see no questions. I think you're going to have a substitute for 272?
Yes, sir.
Okay, we'll need to do that tomorrow morning, first thing. All right. Let's see. Okay, 44, Ed Setzler, Chairman Setzler. Do you have a question?
Mr. Chairman, I wanted to be recognized possibly to present a bill before the committee if it pleases the chair.
Well, you're next on the list anyway. Go ahead, House Bill 290.
Thank you, Mr. Chairman. Bring before members of the Rules Committee House Bill 290, the Patient Representation Act. I've got a bill summary I provided to most of the committee members who are got that for you. What HB 290 does is it clarifies, first of all, consistent with federal regulations, there's 3 status of people who have contact with folks in hospitals and long-term care facilities. There's the legal representative who makes decisions. They're the decision maker that on behalf of and alongside of the patients. Secondly, there's the essential caregiver, the people that are support persons that sit with, or could be sitters, and support the care of the medical professionals, and then visitors. This bill, Mr. Chairman, doesn't affect and govern visitors. Visitors are the pure province of healthcare facilities, long-term care facilities to manage. But what it does do, the core of the bill is that it establishes that the legal representative, that under federal regulation is designated the status being determined by the states. States determine the full legal powers of legal representatives. It establishes that legal representative has access to 1 hour of contact with patients in hospitals and long-term care facilities. And also that subject to the governor's emergency declaration, essential caregivers in a long-term care setting only would have access to people in long-term care setting to provide support to their services. This has been worked out very carefully over a number of weeks. I appreciate Chairman Petrie's work on this. We took a very slow approach to this to make sure that all sides have been heard. And we've gotten input from all quarters of healthcare, long-term care. Appreciate Chairman Newton's support and others. I will say in addition to that, Mr. Chairman, we do have a sort of an emergency override condition where physicians, upon medical emergency, can put a 48-hour delay on this if they're in an operating room or in transplant wards, those most sensitive settings. That the committee process added that to part of the process. And lastly, Mr. Chairman, we have a clarification here that this is not going to in any way interrupt federal funding. We confirmed back on the 22nd that this bill is compliant with our current CMS regulations and have a provision here that this could not interrupt the federal funding to our hospitals and our nursing homes. So be glad to take questions.
Okay, Chairman Cooper.
Okay, I have 2 questions, Mr. Chairman. First of all, you have to designate legally a legal representative, and probably the majority of people in the hospital and in nursing homes don't have that. They haven't turned over the decisions of what happens to them medically to a legal representative. Was that taken into consideration?
Yes, ma'am. I would direct the lady's attention to lines 36 through 38 of the bill. The legal representative is designated by the patient, and it also references Code Section 31-9-2. 31-9-2 is the structure, the multi-tiered structure of the patients making their own decisions, then having people that have healthcare power of attorneys, durable power of attorneys, spouses. That whole structure that exists under current law is specifically invoked in this bill. And for folks that don't have that, it further clarifies that the patient or resident is able to designate that person.
Okay, and then the second question, if I may, Mr. Chairman.
Yes, ma'am.
You're telling me that if a patient's in the hospital and they've had a transplant, and the doctor thinks that they really shouldn't have any visitors, maybe they're fighting a terrible infection, or maybe they're really worried their immune system is so low that they can only hold the visitors off for 48 hours, and after that they must even if it's against the best of medical advice, for the safety and well-being of the patient, they have to let the representative in.
Well, again, I'll answer the question. The answer is we accommodated that specific condition as you alluded to. When you think about the decision maker who is core and essential to the delivery of health care, these aren't people bringing a pound cake, as I know the lady knows. This is the decision maker who's making decisions alongside of the care delivery team. I think many folks, as we work through this process, would recognize more than 1 hour per day is probably needed. However, that 1 hour limitation was further circumscribed by the provision that we gave for the example the lady just shared. That is exactly why, if there was an operation or a transplant or severely immunocompromised conditions, we gave the attending physician the ability to postpone even the core decision making 48 hours as yet another layer of protection. But yes, to the lady's question, we addressed that, but we believe the 48-hour delay was the best way to do it.
So even if you can make core decisions on a patient's care by talking to the physician, not in the patient's room. So you're saying even if it could bring about the patient's death because somebody else has entered this kind of thing, that the doctor cannot, for the best of their patient, hold it more than 48 hours.
To the lady's question, I would tell you that when you talk about a legal representative, this is not a person that's seeking to harm the patient. I think there are many circumstances, again, let me walk through this, ma'am. There are many circumstances in which the legal representative would say, you know what, I don't want to put myself in the setting because we think it's most appropriate clinically not to. The question is, Mr. Chairman, and to the lady's question, is if there's an essential care, if there's a decision maker who wants to be able to see themselves in an appropriate way under conditions set by the hospital, because I think it's very important to understand the hospital prescribes time, manner, place, and all the conditions in which this interaction is going to happen. Given all those things, how can a caregiver make a decision without having some level of physical access as opposed to looking through an iPhone? That's the careful balance this bill seeks to strike, Mr. Chairman. And the lady's questions is precisely the things we've been wrestling with for the last 3 weeks.
Representative Hughley.
Thank you. Thank you, Mr. Chairman, to the author of the bill. Would you speak to what you all have done for long-term care facilities to take care of the roommate in the room? You might want to see your mama, but I don't want you to kill mine.
That's right. I appreciate the question. As we alluded to earlier, this is one of the balances we sought to strike, and I think we have, is the time, manner, place is completely in the hands of the long-term care facility. What we're seeing in long-term care now, even as the facilities themselves are beginning to ease up their restrictions, is this doesn't give someone access to that room to stand 10 feet away from your mama, for example. If my mom's next to your mom, the circumstances can be completely at the discretion of the long-term care facility. They could roll for perhaps my mother or grandmother out to a day room where they do meetings. That's what's broadly happening now. And in a long-term care setting, that's an easier thing to do than in acute care. So we give the facility all the power to decide where exactly that interaction is going to happen, precisely to your question. I would anticipate if we're in a pandemic condition, they wouldn't want even the legal representatives perhaps going back into these rooms. But it does give them the ability to determine however they would have that contact be made. And what we think is a practical matter we're already seeing is they would roll them out to a room where it's the only place those kind of contacts could happen.
Okay, we're not supposed to be debating on this. That would be the last question because we've got other things we've got to do. Thank you, sir. All right. I think that's the last one that we have to present the bill. Now, we do have a rule substitute for House Bill 544. And I think that's Chairman Powell.
I would have to object to this at this time. I haven't been shown this until I got here today.
Well, we can do it tomorrow morning.
Thank you so much.
All right, thank you, sir. All right, I guess now is the time to set the calendar for tomorrow. The first one,
First, I thought we were having an early day.
the first one. Okay. I'll tell you what, I'm getting harassed up here. We will start off in the structured area. House Bill 81, do I hear a move? Move and a second, all in favor say aye. All opposed like sign, it's on. House Bill 469, do I hear a move? All right, I got a move and a second, all in favor say aye. All opposed like sign. Okay, House Bill 451, do I hear a move? Got a move and a second, all in favor say aye. All opposed like sign. Next area is modified structure. House Bill 647. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. It's a modified structure. Yes, sir. All right. Let's see, did I do House Bill 645? Okay, got a move and a second. All in favor say aye. All opposed like sign. It's on. House Bill 620. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. It's on. House Bill 606. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. House Bill 605. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. House Bill 601. Do I hear a move and a second? All in favor say aye. All opposed like sign. House Bill 591. Got a move and a second. All in favor say aye. All opposed like sign. Okay. All those who are voting no on 591, raise your hand. Okay, 1, 2, 3, 4, 5. Okay, it's on. Okay. House Bill 577. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. House Bill 554. Do I hear a move? I got a move and a second. All in favor say aye. All opposed like sign. It's on. Okay, House Bill 450. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. I tell you, those of you who have a bill that you don't say move on, I might start bringing out my red pen. Okay, House Bill 369. I hear a move. Got a move and a second. All in favor say aye. All opposed like sign. It's on. House Bill 364. Do I hear a move? Got a move and a second. All in favor say aye. All opposed like sign. Okay, House Bill 333. I got a move and a second. All in favor say aye. All opposed like sign. It's on. House Bill 316. I hear a move. Gosh. I got a move and a second. All in favor say aye. All opposed like sign. House Bill 92. I hear a move. Got a move. Such enthusiasm, I tell you. Okay, 92. Got a move and a second. All in favor say aye. All opposed like sign. Okay, House Bill 60. I don't have the LC number, but it is a substitute that we voted on the other day and approved. I hear a move. Okay, all in favor say aye. All opposed like sign. It's on. Hold on. Okay. Okay, I started this process off with the bills, and I put House Bill 81 under structured. I need to have that moved to modified open. Is that right, Leo? Need to move to modified open. Do I hear a motion? Got a move and a second. All in favor say aye. All opposed like sign. All right, House Bill 81 is moved to modified open. All right, we will see y'all tomorrow morning at 9 o'clock. Hold on. Chairman Hatchett.
Mr. Chairman, I move that pursuant to Rule 33.3, we limit debate to 1 hour on each bill on all calendars tomorrow, time to be determined by the Speaker.
You got to move in a second. All in favor say aye. Aye. All opposed, like sign. It's on. Hold on 1 second. Chairman Newton.
Mr. Chairman, under the House Bill 81, did you say, or 86?
81, the budget.
Sorry.
81 is the budget. Okay. That's it. We'll see y'all tomorrow morning at 9 o'clock. Oh, excuse me, 8:30 tomorrow, since we're session starting at 9:30, 8:30.